As a subject matter expert for this session, we have Nitish Chopra sir with us. Nitish sir is an independent practitioner in the domain of industrial and labor law, and he is also a faculty at LawSikho's Diploma course in industrial and labor laws. No pun intended. So uh, we also have this dedicated course for HR managers on certificate, naming certificate course in labor, employment, and industrial law. So do check it out if you are a HR manager or an employer. So welcome Nitish sir in the session. It's an absolute pleasure to have you here with us.
Thank you.
Yeah. So sir, before uh, right away jumping into the nitty-gritties of the topic, why don't we start with knowing your journey as a legal professional, like why you choose to master labor law only, and why you thought to be independent despite going rather than going to do a job in a law firm and things like that. Tell us something about yourself.
Okay, and well, I've graduated in law from Punjab University in 2018. So when I completed my higher secondary education, I always wanted to pursue law, and my father is a labor law consultant in Amritsar. So that's why I always had an interest in the field of labor laws. So that's why I chose to be a legal practitioner, and that's why I chose law. And so basically, I practice in labor laws only.
Okay.
So that's why it's just because of my father that I chose the profession of labor laws only.
Acha. And sir, why did you choose to go independent in this domain, and why not go practice under someone else?
I always had an interest in the field of labor laws, and with my father around, he was always there. He's always there to guide me in this field. So that's why I chose this field.
Okay, okay. So, okay, fine. Uh, so, sir, to get the ball rolling, why don't we start with the very fundamentals? My question would be that I have zero knowledge of labor laws. So, my question first would be, what is the code of wages?
See, Anubhav, Code on Wages has been passed in 2019 and it had received the assent of the President in August 2019. So basically, the government intends to subsume four different labor laws into one code, which is the Code on Wages. It has not been implemented yet by the government. There's a notification pending on behalf of the central government. So the four acts which it uh, intends to subsume are the Payment of Wages Act, the Payment of Bonus Act, the Equal Remuneration Act.
Just a minute, sir. People, if you can hear us, can you please type yes in the chat box because uh, Shwas- Shashwata Sahu has said that we are not audible. So can you guys please type yes in the chat box if yes, Rajat can hear us. Okay. Anyone, guys, please quickly type yes or no in the chat box if we are audible and not audible, so that we can quickly resume the session. Not clear. Okay. My internet connection is totally fine. Okay. So, sir, can you adjust your or mic a bit? Can you please hold it closer to your mouth because someone is saying that there are a lot of egos and not clear.
Okay.
Yeah. Okay.
So
Great.
I was, yeah. So I was saying that four labor laws which have been decided by the government, which will be subsumed in this Code on Wages are the Payment of Bonus Act, the Payment of Wages Act, the Equal Remuneration Act, and the fourth one is the Minimum Wages Act. So, as per government's claim, the code on wages will ease doing of business for various establishments, and it will also ensure the coverage of unorganized sector as well. Earlier, under the Minimum Wages Act, the unorganized sector employees were not covered, so they have decided to extend the coverage to the unorganized sector as well under the code on wages. So,
Understood.
yeah.
Understood. Great, sir. So, sir, you told me that you have some PPTs with you there with
Yeah.
which you will be teaching us about every intricacy of labor law. So, why not we start with that?
Yeah. I'll just share the screen.
Yeah, please do so.
I think you have disabled the screen sharing.
Now you can.
Can you see it?
Yeah.
Okay. Okay, so talking about the applicability of the code on wages, code on wages has been made applicable to every employment, whether that employee is a unskilled worker, whether he's a skilled worker, whether he's a supervisor, he's doing some supervisory job or an administrative job. So every type of person has been covered under the ambit of the code on wages. Earlier, under the Minimum Wages Act, there were some scheduled employments and they restricted the coverage of the employees under the Minimum Wages Act. And under the Payment of Wages Act, also there was a wage ceiling of 24,000, and every person who was earning above 24,000 was not covered under the Payment of Wages Act. Now the code on wages has been extended to every type of person, every type of employee. So there's a very extensive coverage of employees under the new code. And moreover, the code on wages is applicable on every type of industry, every type of establishment. So, so it provides a greater coverage to the establishments as well as to the employments. Moving on to the next slide. So I will be discussing what are the key highlights under the new code. Firstly, the major highlight is the minimum wage floor, which has been proposed by the central government. So basically, the minimum wage floor will be decided by the by the central government. Under the erstwhile Act, the Minimum Wages Act, the sole power is vested with the state government to decide the minimum wages, and that brought a great disparity region-wise amongst various states. And now under the code on wages, it will be state government to decide the minimum wages. Now, under the code on wages, the central government will specify a minimum wage floor, and the state governments would not be empowered to decide minimum wages below that minimum wage floor. Suppose the central government says that 8,000 would be the minimum wage floor for the northern region, for the Haryana state, for the Punjab state, for Jammu and Kashmir, and Himachal Pradesh. So all the state governments won't be able to fix minimum wages below that minimum wage floor. So this is the first key highlight from the code on wages. And the other highlight is that the payment of bonus has been mandated to be paid through bank or check only. Earlier, there was a provision under the Payment of Bonus Act that the bonus can also be paid through cash. But now it has been done away with, and it has been mandated that it should be paid through check or bank transfer. uh, the code on wages does not specify the scheduled employments, as I've already told you that there are no scheduled employments under the new code, and it is applicable on every type of employment. And moreover, the time limit for preservation of records has also been done away with. Earlier, under the Payment of Wages Act, there was a time limit to preserve the records by the establishments. And the wage code also provides for compounding of offences. It's just like the criminal law, which provides for composition of offences. So every offence which is punishable with only fine can be compounded by paying just 50% of the maximum amount of fine which is prescribed for a particular offence. So this is a very new thing for the labor laws. It has never been proposed by the government under any other law. So it's a new provision. Moreover, the code on wages expressly transfers the burden of proof to the employer. It states that whenever there's any dispute regarding payment of wages, regarding payment of bonus, the burden of proof would be based in the hands of the employer only. Moreover, the code on wages also provides for an enhanced limitation for for raising a particular dispute, particular claim under the payment of under the code on wages, which is 3 years. Earlier, under the Payment of Wages Act, the the limitation period was only 12 months. Now it has been increased to 3 years. So this will also increase the litigation, and it will also increase the number of cases. And employees would be benefited by this move of the government, and employer is likely to be affected by the number of litigation. Now moving on to the next slide, which is the definitions part, which is a very crucial part, and many new definitions have been introduced, and the government's agenda was that to standardize the definition under various labor laws. So under various labor law, there was different definition of employee, there was different definition of wages, but their basic agenda is to standardize the definition which they have achieved through those code on wages. The definition of employee, I've already told that it includes every type of person, whether he's a supervisory, managerial, administrative work, whether he's doing the skilled, semi-skilled, or a manual or an operational work. Establishment, the establishment would
Sir,
include.
sir, can you just zoom a bit on the slides because some people are saying that that it is not visible. Just a little bit zoom. That would be great. Yep. All right. Thank you so much, sir.
So the establishment, talking about the establishment, the word establishment would take into ambit various factories, various shops and commercial establishments, and also the educational institutions. The offices of lawyers would also be included, and agriculture sector has also been included under definition of establishment. So this is the new move by taking into account the agriculture sector. Now moving on to the next slide, which is the definition of wages. The definition of wages. The definition of wages has been introduced by the government. This is a wholly new definition, which is not prevalent under any existing law. So the definition of wages includes every type of emolument which the employee is earning while on duty under the terms of his employment. And there are some exclusions under the definition of wages which have been listed under clauses A to I, which have been presented in this table as well from A to I. So basically the HRA portion, house rent allowance, conveyance allowance, the overtime allowance, any commission which is being paid to the employee are excluded. And there's also another clause attached to this which regulates the quantum of the exclusions part, which states that whenever the sum of the exclusions, which is from A to I, it exceeds the 50% of the wages, then the part which is in exceeding, which exceeds the 50% would be added back to the wages. So I can demonstrate this through a table, through a case study, which is on the next slide. So basically, the basic wages are in the inclusion part. The HRA is in the exclusion part. The conveyance is also in the exclusion part. So with the new definition in force, the sum of exclusion should not exceed the 50% of the wages. And if they exceed the 50%, the amount by which they exceed the 50% would be added back to the wages. So in this case, the exclusions part, the sum of exclusion part, which is the HR and conveyance, is 6,000. So it exceeds the 50% of the wages, which is 5,000 by 1,000 rupees. So as per the new definition, the wages under the code would be 5,000. That comprises of basic wages of rupees 4,000 and the excessive portion of 1,000. There's another case study in which the basic wages of an employee is 6,000. The HRA and the conveyance part, which is in the exclusion part, is 4,000. So in this case, the 50% of the wages is 5,000, and the sum of exclusions, which is 4,000, does not exceed 5,000. So in this case, the wages would be only 6,000 only. So there won't be any adding back into in this case. Now, I already told that four different laws have been subsumed into this code on wages. So firstly, I will be talking about the Payment of Bonus Act. So the Payment of Bonus Act, the provisions of the payment of bonus under the new code have been made applicable to every establishment which is employing 20 or more persons in a particular accounting year. So, so this is the same applicability which was prevalent under the Payment of Bonus Act. So the applicability has not been changed by the government. The eligibility for payment of bonus is also the same, which provides that an employee should have worked for at least 30 days in an accounting year in order to be eligible for payment of bonus. And there are also disqualifications for payment of bonus, which are on account of dismissal from service for any fraud, for any righteous behavior, for any theft or any misappropriation of the property. And there's a new disqualification which has been introduced under the Code on Wages, which is on conviction for sexual harassment, which was not earlier there in the Payment of Bonus Act. So this is the new disqualification. Moving on to the next slide. So similar to the Payment of Bonus Act, the Code on Wages also provides that the minimum bonus would be 8.33% and the maximum bonus which would be computed as per the profitability of the business would be 20%. So the maximum is 20% and the minimum is 8.33%. The provision has remained intact under the new code as well. So the bonus has to be paid through check or through bank transfer only under the new code, but under the Payment of Bonus Act, there was a provision to pay bonus by cash also. So the government has also introduced an infancy period for the benefit of the newly set up establishment for first 5 accounting years. In case any establishment does not earn profit during first 5 accounting years, then they are not liable to pay bonus under the new code. This provision was also prevalent under the earlier Payment of Bonus Act. Now, moving on to the next concept of payment of wages. So the government has mandated that every wage has to be paid through coin, through notes, through check, or through electronic mode of transfer. And they have also introduced a new clause on time limit for payment of wages. So every employee who's employed on daily basis has to be paid wages at the end of the shift. Every employee who is employed on weekly basis has to be paid wages on the last working day of the week. Any employee who is employed on fortnightly basis would be paid before the expiry of the second day after the end of the fortnight. And every employee who is employed on monthly basis would be paid wages before the expiry of the 7th day of the succeeding month. There was a benefit under the Payment of Wages Act for bigger establishments which were employing 1,000 or more workers. So they had this benefit that they can pay wages to their employees by 10th of the succeeding month. So this benefit has been taken away by the government and it has mandatorily provided that every establishment has to pay wages by 7th of the succeeding month. So this is a key change for the bigger establishments. Now, talking about the payment of wages, they have also permitted certain deductions. So I will be discussing some of the deductions which are in the nature of fines. When you impose fines for certain offenses of your employees, and then there are deductions for absence from duty, damages or loss of goods, any deduction which you make for any damage an employee has caused to your property, and any deduction for recovery of advances is also permissible under the new code. Any deduction for providing any amenities and services by the employer is also permissible. Deduction on account of income tax, which is TDS, and the provident fund is also permissible. And the government has also specified that the deduction, the entire sum of the deduction should not exceed 50% of the employee's total wages, to which he is entitled for a particular month. So the deductions have been limited. So now moving on to the next slide, the next concept of the minimum wages. So the state governments have been empowered to fix the wages as per the skill levels of the employees. So currently also the governments are fixing wages as per the skill level, which is unskilled, by categorizing employees into unskilled categories, skilled categories, semi-skilled and highly skilled. And the minimum wage floor, which is the new concept, the central government has been empowered to fix minimum wage floor for a particular geographical area, and the state governments won't be able to fix minimum wages below that minimum wage floor. So the code on wages also specifies that the state government shall ordinarily revise the minimum wages at an interval of every 5 years. So this is the same provision which is already prevalent under the Minimum Wages Act. Now moving on to the next concept, that is equal remuneration for equal work. So earlier under the Equal Remuneration Act, there was a parity for payment of wages for the same skill work for amongst only men and women. Now they have under the code on wages, the government has told that the wages for a particular work for which involves same skills shall be paid at an equal level for every type of gender. So they have provided protection to transgenders as well under the new code. So same work or work of similar nature, which is very relevant. It means that work in respect of its skill, effort, experience, and responsibility required are the same. So it's not just the skill, but also the responsibility, the experience, and the effort which are involved in a particular job should be the same. And when they are performed under similar working conditions by employees. Now, if I have an employee who's working in Delhi and there's another employee who's working in Amritsar, and maybe the skill level in that post is the same, but the working conditions might be different. So in that scenario, there can be differentiation amongst the pay scale of the employees. So the working conditions should be same in order to standardize the payment of wages to the employees. Then moving on to the next concept, which is the claims. So I've already told that the limitation period has been raised by the government, and now the limitation period in order to bring any claim before the Assistant Labor Commissioner is 3 years. Under the Minimum Wages Act, there was a limitation of only 6 months, and under the Payment of Wages Act, it was 12 months. So it has been drastically increased by the government in order to help workers. So this will also increase the number of stale cases, and employees may bring some frivolous cases after termination of their employment after just 2 or 2.5 years, and and the employer will have to preserve the records till that time. Now, moving on to the offences and penalties under the wage code. So the penalties for certain offences have been increased multifold. Like say for under the minimum wages act, if some offence had a penalty for say rupees 500, now it has a penalty for rupees 50,000 as well. If the employee does not get the minimum wages under the minimum wages act, the maximum fine which is permissible is rupees 500 under the minimum wages act. Now the maximum fine has increased to rupees 50,000. So the the offences are more deterrent now, and this has been done by the government in order to deter the employers that the wages are paid in time, the minimum wages are complied by the employer. So the government has also specified enhanced penalties under the new code whenever there is any repetition of the offence by the person, by the employer or as any agent, then he would be liable for enhanced penalties under the new code. The government has also introduced the concept of inspectors cum facilitators. So earlier there was only a provision of the inspectors who used to visit the establishment and conduct inspection under the various statutes, but now they have also become facilitators. So they will be advising the employers as well as the employees regarding the implementation of the code of wages. So this is a very good move on behalf of the government. Yes. Now this is the new concept, which is the compounding of offences. So the government has permitted compounding of offences under the Code of Wages, which are punishable with only fine, and the compounding, the amount which would be involved for composition of offences would be 50% of the maximum fine which is provided for a particular offence. So that's it with this slide.
All right. So, sir, as we have a quite limited number of participants, why don't we open the forum for people to ask questions? And if they have
Yes.
any pertinent question, then they can come live and ask. So, guys, yeah, you guys can unmute yourself and ask Nitish sir live on the chat. If sir, if you're done with the slides, then you can stop the screen sharing.
Wait.
Do anyone has any question, or should I ask something which is pertinent to the session? What do you guys say? No one? Okay, let me ask, sir. So you have explained major parts. You have almost addressed everything which is covered under the umbrella of Code of Wages. S- So the first question which comes in a newbie like me is, what legislative reforms do this Code of Wages intends to bring in the present system?
The new legislative reforms
Hello.
which the yes, am I audible? Yes. Am I audible now?
Yeah, yeah. Please go ahead.
So, Anubhav, the new legislative reforms which
Yeah,
the
yes, you
government,
are.
so the new legislative reforms which the government has proposed under the new code is the first one being the minimum wage floor, which is the new concept, and one can be the randomized web-based inspection procedure, which has been introduced by the government for the first time. So the government has allowed web-based inspections in which the employers only need to send scanned copies of their registers to the office of the inspectors. The inspectors would not be visiting the premises of the establishment of the employer. The employer only needs to send a scanned copy of the registers and the returns which are required to be maintained under the code on wages. So this will decrease the amount of harassment which is caused to the employers in cases of physical inspections.
So this is one. One is that in order to cut down the exploitation of employers and HR by the labor law inspector,
Yes,
the e-documents have been promoted by the government. So this is
yes,
one legislative reform. Second one,
yes. The second one is the compounding of offences. Earlier, under any labor law, the compounding of offences has never been provided or proposed by the government. So this is a very new concept which allows the employers to compound their offences outside the criminal courts. So this is a very, very good move from the government. for the sake of promoting business and ease of doing business. They have also, yeah, the other move is they have also provided that only a single register has to be maintained by the employer under the code of wages. Under the erstwhile acts, there were multiple registers. Under Minimum Wages Act, there were four registers. Payment of wages also prescribed four or five different registers. So only a single register has to be maintained by the employer. So this is a really good move.
Great, bravo. So cutting off the formalities to catapult the process of all the formalities under labor law. So, sir,
Yes,
as you said, ki this code of wages is still not effective yet. So,
yes.
why do you think why the government hasn't made it effective, and why this old four laws are still being implemented and govern all the practices of labor law?
Yes. Anubhav, the basic reason is that the code on wages is not entirely it does not contain the entire provisions. It has the specific rule making provisions for the state governments and the central government as well. So until and unless the rules are made effective, the code on wages cannot be implemented. And moreover, looking at the current scenario of which is the economic slowdown which the country has faced in the recent past months. So that's why that can be the other reason why the code on wages has not been implemented by the parliament.
Okay, sir. So, sir, another question can be: do employers require to reevaluate their existing wage structure, or or the old one can still persist?
Anubhav, looking at the new definition of wages, which is a very typical definition, which is a very confusing definition in itself. Although the government had said that they are going to provide a standard definition under every labor law, and they are going to ease the definitions. So, but it's a very confusing definition. So, looking at the definition, various components have been excluded, but they have also limited that the exclusion should not exceed the 50% of the gross wages. So, in order to survive the competition, I think the industries will have to revisit their salary structures. And many amendments have already been proposed by the EPF also. The EPF department, the EPF Act. They have proposed that the EPF Act will be amended, and they are trying to adopt the similar definition. And moreover, under the there are I would also like to mention that there are three other codes which are in line, that are code on social security, code on occupational safety, and there's another code which is also in line, which is code on industrial relations. So under that codes also, the government has proposed a single definition, which would be a uniform definition, which would be just similar to the definition of wages under the code of wages. So I think the employers will have to change their salary structures.
Great, sir. So, sir, as we know, and if we look at the past few decades, whenever an amendment comes to the law, it always leads to increased litigation and increased number of disputes in that particular niche. So, sir, is compounding possible after the prosecution has been initiated?
Yes. Under the new code on wages, compounding has been introduced for the first time, and it is also possible that the offense can be compounded after the prosecution has been initiated by the inspector. So there is a provision under the code on wages to compound the offences even after the prosecution has been launched against the employee. He can always contact the inspector and get the offence compounded before the appropriate authority, which will be notified by the government at the later stage.
Great, sir. Okay. So having uh, so talking of disputes, sir, uh, what will be the impact of code of wages on the labor law practice for lawyers? Can you please answer this question by addressing each category of work separately, like what will be the impact on compliance work, what will be the impact of due diligence work, advisory work, litigation work, and those sorts of things?
Okay. So as far as the compliance work is concerned, the government has already told that they wanted to encourage the ease of doing business. So they have provided just maintenance of a single register under the code on wages. So as far as the compliance work is concerned, that will be reduced for the employers as a single register needs to be maintained under the code on wages. And for compliance work, I think it's not just the maintenance of multiple registers or a single register. There's also concern regarding accurate maintenance of a register. Since the definition of wages is very complex, so the employer has to ensure that the entries are correct and the calculations of minimum wages, the calculation of wages, and the calculation of bonus is correct, and it is as per the mandate of the code on wages. So this is regarding the compliance work. As far as the litigation part is concerned or the advisory part is concerned under the code on wages, so I think the litigation is obviously going to increase because of the enhanced limitation provided under the code on wages, which is 3 years. Earlier it was 12 months under the Payment of Wages Act and 6 months under the Minimum Wages Act. So the litigation will definitely increase. Moreover, under the code on wages, they have empowered the trade union members to file a class action claims against the employer. So class action claims on behalf of various employees can also be raised on behalf of the trade union activists. So moreover, the burden of proof, which has been expressly shifted towards the employer. So uh, this will also make the employer stand in the court difficult because he will have to prove that the compliance has been adequately reported under the act. So, but looking as far as the prosecution is concerned, which is the criminal for the criminal offences, the code on wages provides for compounding of offences. So this will also decrease the number of prosecutions which are launched under the act, and many of the prosecution which have been launched can also be compounded at the later stage at any time. So this is
Yeah.
all about the compliance as well as the litigation part.
Okay. As we have seen that major reforms has been introduced. Hello, I'm audible. Hello.
Yes, yes, yes.
Yeah. So as we have seen that many new reforms have been introduced. So, sir, will there be any change on due diligence work? Uh, because when the rules which needed to be comply have changed, the standard of diligence should also be increased on the part of employers. What do you say?
Yes, definitely, Anubhav. The diligence has to be increased because as I've already told that the offences, the punishments for offences has been increased multifold. An offence which was liable for payment of fine up to 500 has been the payment of fine for that particular offence has been increased up to 550,000. So obviously the diligence has to be increased. The employers will have to ensure that the wages are paid in time before 7th of the next month. And moreover, the bonus has to be mandatorily paid through bank transfer or through check only now. Earlier, employers had this provision, they had this power to pay bonus only through cash. Now they will have to pay it through bank transfers only. And yes, and the other thing which will be involved in under the due diligence would be the calculation of wages, which would be a tricky part. And the employers will have to ensure, and the HR managers will have to ensure that the wages are properly calculated as per the mandate of the score.
Great, sir. Uh, Bravo. So, sir, this brings me to my next question. What will be the impact of code of wages on various sectors of economy? Like which areas will boom, which areas will see, which areas will witness a plummet and will cut off the employees, and yeah, overall impact of economy on economy of the code of wages.
Anubhav, as per my opinion, the overall impact on the economy would be a standard impact. There won't be a variable impact on different sectors, I think, because it has been mandatorily extended to every sector of the industry, irrespective of the wage ceiling of the employees, irrespective of the sector in which the industry is running. So the overall impact would be the same. The employers will have to ensure that they duly comply with the code on wages because of the deterrent effect which is due to the enhanced penalties. And moreover, under this new code, there's a new provision which has been introduced for the first time, which is that the employees can directly launch prosecution of the employers. So under the earlier provisions of the earlier statutes, the prosecution of the employer could be launched only after the sanction of the inspecting official of the jurisdiction under which the employer is running his business. So now no sanction is required by the employee in order to launch prosecution of the employer. So I think the cost of the business would all obviously increase with the new code on wages. Hello. Yes.
Hello.
Yes, and
Yeah, so I'm so sorry. Yeah, Sushil, please go ahead with your question, please.
Yeah, I just wanted to ask Nitish. Now the central government has this minimum floor that they have set for the wages, and at the same time, the Minimum Wages Act is also there. What is the interplay between these two? Which will override which? And what is the need at all for a state Minimum Wages Act now, if the central government is setting or based on geographical areas?
yes. So currently, Sushil, under the Minimum Wages Act, there is no requirement of setting of minimum wage floor. So, and the state governments are not obliged to follow that minimum wage floor, even if it's set by the central government. It's only in the nature of an advice by the central government that this would be the minimum wage floor, and it is not mandatorily to be followed by the state government. So, as far as the code on wages is concerned, whenever it's implemented, that minimum wage floor has to be mandatorily followed by the state governments whenever they will be deciding the minimum wages for a particular set of establishments. So currently, there is no deterrent effect. There is no mandatory requirement by the state government to follow that minimum wage floor.
So it's of no use as of now.
As of now, it's of no use. But once it's implemented, this code is implemented, then it would be statutory requirement for the state government to follow that minimum wage floor.
Okay, so when it's implemented, will it mean that the Minimum Wages Act will all of the states have to be repealed, or they can maintain it and they can pay more than what the central government, not less?
Yes. The minimum currently the Minimum Wages Act is a central act only. There are no state level acts for minimum wages for payment of minimum wages. It's only that they are empowered. The state governments are empowered under the Minimum Wages Act to set their own minimum wages for their respective establishments operating in their states. So once it's implemented, this code on wages is implemented, only then the minimum wage floor would become deterrent for the state governments to follow.
Okay, and there'll be no more Minimum Wages Act then.
Yes, then there won't be any minimum wages. That would be repealed.
Okay. Yes, thank you.
Okay. Do anyone has any other question? Any other question? We have limited number of participants today, so you guys can get individual attention of the expert and can get a very detailed answer from us. So if anyone has any question, it is the best time to ask.
Yeah, when do you expect this to be notified?
Sushil, maybe after the situation returns to the normalcy, because looking at the current scenario, moreover, the finance minister in a today's speech emphasized that the government has already planned for minimum wage floor. Maybe they will they will implement this code on wages in a month or so in order to implement the national minimum wage floor in order to prevent the hassles which the migrant workers have underwent during this lockdown situation. So maybe anytime soon.
Okay, thanks.
Any other question, people? Any other question? Quickly.
Hello, this is Vishnu.
Yeah.
So the bonus act actually bonus section tells that wage states can fix their own wage limit for calculation of bonus. So now we are 21,000. Now the new wage code says the state governments can themselves fix the wage limit. So it will be burden, the compliance burden will be high, for HR and other corporate functions to calculate the bonus, and for the employees also.
Yes. Under the new code, it has been provided that the state government also can provide for uh, the wage ceiling, which would be applicable for the payment of bonus to its employees. So yes, definitely, uh, this will also increase the burden of the HR managers if they are working in if the establishment is running offices in different states only. If the establishment is working only in one state, then there won't be any effect. There hardly won't be any effect because there would be only one wage ceiling. If the establishment is operating in multiple states, then only there would be a difficulty for the HR managers.
So what is the difference between worker and employee?
Yes, under the code on wages, they have introduced two different concepts. One is a worker and one is an employee. So for every benefit which is payable to an employee, the definition of employee would be considered. They have extended every benefit, whether it is wages, whether it is minimum wage or bonus, to the employees only. They have not extended it to the workers. Workers have been used just to for the purposes of calculations of the minimum wages. Whenever their daily living, the cost of their living has to be considered for the calculation of wages. Only then the workers definition would come into play. Otherwise, there's no rule attached to definition of definition of workers under the code on wages.
Vishnu sir, does that answer your question?
Yes.
Right. All right. Next question. Next question, please. Adi has something to say. Adi? Yeah. I have unmuted you. Do you have any question? No? All right. Sir, I have a couple of questions for you. Just quickly. So you are an independent practitioner. So, uh, on the and in the same way, you are also a young lawyer. So, what are the challenges you faced while setting up your independent practice during the initial years of your career as a labor law practitioner?
Okay. So it's been just 6 months since I have started my independent practice. Earlier, uh, I was in Ludhiana with my mentor. I spent 1.5 years with him learning the intricacies of the labor laws, and there was like quite a deep research going on in his office whenever the labor laws were concerned. And so it, I was always into the labor laws since the beginning of my law career, since the beginning of my law school. I always used to research the labor laws the most because of my father. I've already told that he's a labor law advisor in Amritsar. So I've always had his help regarding labor laws. Whenever there was any point of discussion, I used to go to him and just mention that provision, and he used to help me and guide me. So, so slowly and gradually, I've learned some intricacies of the law, of the labor laws. So I'm still learning. I'm still learning with this course, in which I teach the learners from the LawSikho. So I get to learn many new things from them also. Still learning.
Understood. So, but the question was, what are the challenges you faced in the initial years? Like, did you suffer the lack of capital, or did you suffer things like competition or some sort of hurdles?
Competition would always be there. Competition is not going to increase because competition is never going to decrease. So if capital was never an issue, capital was not an issue. My father always supported me, and the other issues were maybe that could be the legal research, which had to be taken care by myself only. There's no other issue.
Great, sir. So, sir, you are also a faculty at LawSikho's labor course. You have been teaching in our courses for quite some time now, I would say. So, why did you agree to teach in LawSikho? And where do you think the LawSikho's courses help its learners?
See, Anubhav, the LawSikho is definitely the leading platform in the area of online education in today's era. So I've always been fascinated by the courses which it provides since the beginning of my law school. So by joining this course, I also got to know many persons, their opinions and regarding various aspects of the labor laws, because the law always involves the interpretation part. And whenever you discuss law with some person, you get to know a different interpretation from his point of view. So that's why I chose teaching in this course with LawSikho, because I would get an opportunity to discuss labor laws and also to get to learn the different perspectives which other people hold regarding some provisions. So that's the
Understood,
main reason.
sir. Understood, sir. Understood. Um, so, sir, what is the need of a platform like LawSikho? Like, why can't I just simply open up a Aware Act and cram some case laws and go ahead with the practice? Why can't I do that? Or why can't I learn everything from my internship if the practical exposure is a reason? Why? Where does the courses, according to you, actually come up and really gives value to the learners?
So, Anubhav, the courses at LawSikho are all about the practical experience a lawyer, which a law school student cannot avail in while he's in the law school. So the LawSikho provides a practical experience to uh, every every student who's involved in the LawSikho courses, uh, whether he's from a non-law background as well. So this is the really good thing from the LawSikho, that it gives practical training and it increases the practical experience also for its learners.
People, there is no shred of doubt that in law colleges, law schools, we don't get to learn the practical nuances of the profession. We don't get to learn how we learn the provisions of law, we learn case laws, but we actually don't know how the job is done, how what are the laws to comply with, what are the uh, how you will deal with the matters if a harassment complaints come to you, what are the notices to be given, how to draft a contract, and how to deal with the employment contracts and things like that. And secondly, if someone says that I will learn these things in my internship, then please get this thing straight. I have interviewed number of HRs, number of partners and lawyers. Everyone says that one of the major mistake done by students if during their internship is they think that they are in the internship to learn. That's just not true. They are in the internship to perform. You are supposed to learn from other sources like your law college or the online platforms or any other places, and you are supposed to uh, fetch the results of that learning in the internship. That is how you score a pre-placement offer, that is how you get recommendation for good places, and that is how you make your way up to the top notch organizations. So please get this thing right in the head that when we are interning at some place, we are there to deliver some fathomable tangible results and not just to fool around and ask every basic to basic question to the your boss and waste their time as well. So then you are just another guy in the crowd. But if you really want to distinguish yourself from others, if you really want to shine, if you really want to get to play in that rare area, then you have to be proactive with your career, and then you have to gain that competitive edge by learning those practical nuances, whether it is labor law or it is any other labor law, intellectual property laws, copyright laws, criminal laws, civil laws, for any matter. Or labor law, one thing about labor law is key, it is not one or two or three statutes. It is a combination of, I guess, multiple statutes: Factories Act, Employment Exchange Act, Industrial Disputes Law, Standing Orders Act, Maternity Benefits Act, and I can't even remember all the names. Payment of bonus, payment of gratuity. So how you will imbibe all these laws in by just learning labor law in one of your semester? How you will actually deliver the value? So that is one thing. So that is where the LawSikho's courses come in. I have sent the link of our courses in the chat box. You guys should must check it out. And if you have any doubt regarding labor laws or any our courses, you guys can contact me. This is my number. Nitish sir, I would request you, can you please provide your email ID, and if you are comfortable, then your phone number to our attendees, so that if in case of any unanswered query, they can reach out to you.
Yes, they can have my email ID. I'll just type it in the chat box.
Nitish sir? Yeah, please. Thank you so much. Yeah.
Yes.
All right, sir. So people, I'm asking for the last time because we are about to end the session. Do anyone has any question from sir or from me regarding the course? Yeah, Kunal sir, Kunal Pandey ji, go on, go ahead. Kunal Pandey, do you have a question? You just raised the hand. He left. I think that was by mistake. Okay, sir. Thank you so much. It was a really enlightening session. I personally learned a lot. It was a bit hardcore and technical session, but yet I will get to learn a lot. It was quite enriching. Thank you so much, sir.
Well,
All right. Okay, people. Break a leg. Have a good day. Bye.